Yes, I'm calling expert Lucy Claridge, and it will be followed by expert Alexander Santhaki, who jointly prepared a statement that was filed for this public inquiry. I'm very thankful to Dr. Santhaki for having come all the way from Oxford to be today with us. And I will give the floor to Mrs. Lucy Claridge, who is going to introduce herself and give her evidence.
Thank you. So,
sorry, this is to be a summary or what?
Yes, correct, sir. It's going to be a summary with the key points in her evidence.
Right. Thank you.
Thank you. So, as introduced, my name is Lucy Claridge. I'm a solicitor of England and Wales, but I'm also currently legal director at Minority Rights Group International. We are an NGO with headquarters in London, but with offices throughout the world, working to secure the rights of ethnic, religious and linguistic minorities and indigenous peoples. We have consultative status with the UN Economic and Social Council, observer status with the African Commission on Human Peoples' Rights, and we are a civil society recognised with the Organisation of American States. My specific experience, I litigate rights before international and regional courts and mechanisms to promote and protect the rights of minorities and indigenous people, with a particular focus on land rights, on political participation and wider participation and anti-discrimination issues. And therefore my expert evidence is drawing on my experience as a legal practitioner. Most recently, for example, I won a case before the African Court of Human and People's Rights on behalf of a community of 35,000 living in Kenya. It was the first ever judgment on the right to culture from the African Court of Human and People's Rights, and it recognised the links between communities' right to culture and also their land and resources. So the expert statement was prepared jointly with Alex Santhaki. So what I intend to address are the first two parts of the witness statement, the concept of minority rights under international law, and then the application of that concept to the Seven Sisters market traders. We've both read the various documents, including the statement of case, the statement of reasons. We've visited the market. We've read the more recent documents, including the 2017 Equality Impact Assessment and the new Section 106 Agreement, deed of variation.
Can I just ask you, Ms. Claridge, have you also seen the Council's legal submissions that were tabled at this inquiry last week? Yes, I believe you mean, by which you mean the statement of case and the statement of reasons? No, a document headed legal submissions for the Council.
Okay.
I did send a copy of these to both experts, but since it was sent just at the beginning of last week, and then there was an exchange between councils, and Mr. Corner said that they would not be addressing issues of legal questions and that they would rather leave that for their own submissions. I didn't make a point that they were going to be relevant for their expertise today at all.
Well, just so that I understand the position, I take it that the points raised in the Council's legal submissions will be addressed by you in your closing submissions to the inquiry. Is that right?
That was my understanding from Mr. Corner's intervention. He made a point that that was rather for submissions, so I'm happy to deal with it that way. So I didn't put that to my experts.
No, but okay.
So can I just say something briefly on that? It's not for me to decide how Ms. Faria Tinter puts her case. I said when the discussion was held last week on these two ladies coming to give evidence, that I would not be cross-examining on legal matters. Now, it's for Ms. Faria Tinta and her witnesses to deal with their material in the way that they see fit. I'm just setting out how I'm going to deal with matters so far as I'm concerned.
See, it may be that I need to put one or two questions to Ms. Claridge to gauge her response to points that the Council have made, but it will be difficult to do that if she hasn't had the chance to read the submissions. So I will have to see, but when I've heard the evidence, I'll see whether those questions are still appropriate.
By all means, they are experts in their field, and by all means you can ask any questions of clarifications. They will be giving you their point of view. What I did not expect them to do was to give a full response to these submissions, because with that, we are going to deal with that when we address, when we write. I haven't finished. When I address that point in our submissions later on.
And that's fine. That's what I said. It's a matter for Ms. Faria Tinta, not for me.
Thank you very much. Okay. Ms. Claridge, please carry on.
So I apologise. Just to clarify on that, I haven't seen the submissions that were recently made, but I know that Ms. Sandaki has, and we have discussed them. So I think I have an essence of what was raised, and I may be able to ask questions and may, in fact, touch on that within my evidence now. Okay, so moving on. What I will first provide evidence on is the concept of minority rights under international law. So the concept of minority rights come from well-established principles within international human rights law that all people are entitled to the enjoyment of fundamental human rights without discrimination. And this is protected in principle within Article 1 of the Universal Declaration on Human Rights, which states that all people are born free and equal in dignity and rights. So the protection of minorities is rooted in those principles of equality and discrimination, but it also seeks to advance the rights of persons belonging to minorities, such as the market traders, to participate in decision-making, to enjoy their own culture, to progress and practice their own religion, and to use their own language. And indeed, the United Nations Committee on the Elimination of Racial Discrimination has taken this further by defining discrimination as any distinction, exclusion, restriction or preference based on race, colour, descent or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural or any other field of public life. Moving on from that, the International Covenant on Civil and Political Rights requires states, including the United Kingdom, to respect and to ensure all individuals within its territory to the rights without distinction of any kind, such as race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. And Article 27 of the International Covenant particularly requires ethnic, religious or linguistic minorities or persons belonging to such minorities should not be denied the right in community with other members of their group to enjoy their culture or to use their own language. And this is further qualified by General Comment number 23 of the UN Human Rights Committee, which states that Article 27 establishes and recognises a right conferred on individuals belonging to a minority group and which is distinct from all the other rights which they're entitled to enjoy under the Covenant. So there is no single definition of a minority under international law, but there are various understandings. and the United Nations Declaration on the Rights of Persons Belonging to National or Ethnic and Religious and Linguistic Minorities refers to minorities based on national or ethnic, cultural, religious and linguistic identity. But greater guidance was provided by the UN Special Rapporteur in the 1970s, who defined minorities as a group numerically inferior to the rest of the population of a state in a non-dominant position, whose members possess ethnic, religious or linguistic characters differing from those of the rest of the population, and show, even if only implicitly, a sense of solidarity directed towards preserving their culture, traditions, religions and language. So the existence of minority is therefore both a question of fact that requires consideration of both objective and subjective factors. The key subjective element is the existence of individuals who self-identify as belonging to a minority. And this is particularly picked up by the Framework Convention for the Protection of National Minorities, which was ratified by the United Kingdom some 20-odd years ago. And this makes it very clear that every person belonging to a national minority shall have the right freely to choose or be treated or not to be treated as such, and no disadvantage shall result from this choice or from the exercise of the rights which are connected to that choice. And then moving on to the objective criteria, again, the framework, the commentary around the Framework Convention on National Minorities, it states that objective criteria are not only the elements, but rather that they should be interpreted in light of the individual's subjective choice. So objective factors may include the existence of a shared ethnicity, language or religion, but then moving on from that, the subjective factor is the belief that they belong to and self-identify as a minority.
Just, if it helps you at all, Ms. Claridge, there is no dispute in this case as to the fact that some people are part of an ethnic minority. That's not a point that's disputed by anybody in this inquiry.
No problem. I will move on anyway, which I was going to do, to the application of the definition of a minority to the Seven Sisters market traders. So over 50% of the respondents to the business survey conducted at the market and included within the equality impact assessment identified as belonging to a Latin American or Hispanic background. And many of those employed by businesses identify as people belonging with Latin American or Hispanic background. They also, the Spanish language is the primary language spoken in the community, and the learning of and speaking in Spanish is encouraged by parents of second-generation Latin Americans. The London Latin American community also has a distinct culture, which is celebrated through participation in cultural events and activities. And the commercial centres, such as the Seven Sisters Market, function as that informal cultural centre for London's Latin American families. The Seven Sisters Market is also the UK's second largest concentration of Latin American businesses catering to the London Latin American community. And it's the use of these services and shopping is another important way in which the Latin American community can engage in their culture on a daily basis. And indeed, there has been research undertaken by Queen Mary University, which has shown that commercial places are important for the community to maintain their products and their customs. And indeed, I believe that the Council has in fact recognised the distinct culture of London's Latin American community in Haringey, and the original planning equality impact assessment concluded that the loss of the existing shops and market poses a potential threat to the cultural connections of the Latin American community employed at and visiting the market, given the evidence that the market provided a hub for social as well as commercial interaction for this group. and the Court of Appeal found that the Council had failed to give due regard to the need to promote the equality of opportunity and good relations between persons of different racial groups. So looking at what some of the other characteristics, the Latin American community in Haringey is in a non-dominant position. It's difficult to know exactly how many are in Haringey, because I don't believe that there's actually been a census conducted by Haringey Council to determine how many live there, but approximately 1.7% of London's population in 2013 are Latin American, so it's obviously very numerically inferior and non-dominant. They also have a substantially lower household income. And again, this has been proved through research by Queen Mary University. And they are more likely to be deprived than the London average. So in summary, looking at all the factors which should be taken into account in protecting minority rights within the UK and within this development, the proposed development is likely to economically marginalise the Latin American traders. Many of those who've surveyed have said that proposed new rent levels would be unlikely or highly unlikely to support the existing businesses to continue operating. And many believe that discrimination is a major barrier to improving their quality of life. And we can also see that the traders themselves have conducted advocacy which shows their determination to prove their distinct ethnic identity, and this has emphasised the importance of the Seven Sisters Market as a cultural hub for the community. It provides a village, it provides an informal cultural meeting place, and it provides community members with a sense of belonging. And therefore, the Seven Sisters Market traders do meet the international understanding of a minority, as explained earlier, and therefore they're entitled to protections afforded to minorities under the various international treaties, including Article 27 in the International Covenant and the Framework Convention of National Minority, and these aspects have not been taken into account within this development. Thank you.
Is there anything else that you want to draw from this witness?
Yes, I have only 2 questions, and we can move on from there. If you perhaps have some questions that you wanted to pose to Ms. Claridge, would you like to ask before?
Has the evidence in chief?
No, not yet.
Finished? No. Right.
Mrs. Claridge, this last remark that you made concerning entitlements under Article 26 from the ICCPR, I'd like to give you the opportunity to comment on positive obligations by the UK to protect minorities under this particular international regime.
Thank you. So it was Article 27 which I particularly referred to. In summary, the position with regard to the application of international law domestically is that legislation should never be construed in an inconsistent manner with binding international law which a state has become a party to. So, for example, we have the European Convention of Human Rights, which was signed many years ago in the 1970s by the UK. Now, that has been put into direct effect within direct legislation, the Human Rights Act. But before the Human Rights Act was in place, the European Convention was binding on the UK. And indeed, there are many decisions, even dating back to the 1970s, calling upon the UK to comply with the European Convention, decisions issued by the then European Commission on Human Rights. And even now, if the Human Rights Act were repealed, the European Convention on Human Rights would continue to apply. So I use that as an example to show that international law is used must be used to interpret and to should be implemented within the domestic legal framework. And then looking, for example, at the Human Rights Committee, the UN Human Rights Committee, which monitors the extent to which the UK government complies with the International Covenant on Civil and Political Rights. So the UK government submits regular periodic reports to the Human Rights Committee. It's very prompt in doing so and actually submits quite thorough reports, unlike some other states. But it does specifically comment in its reports on the extent to which it implements the international covenants in the UK and the compliance with those standards. So, for example, I believe the 7th periodic report was submitted in 2012, so relatively recently, and a new one will no doubt be due soon. Thank you.
So when you say the UK government, in the concept of instrumentalities of that government, would that be falling also the actions of local authorities such as Haringey?
Yes, I believe so. As I said, international law needs to be fully reflected in domestic frameworks, domestic policy, domestic legislation, and that would, in my view, apply to planning legislation and planning policy.
And finally, I'd like to ask a question concerning CPO in particular. Would CPO, in your view, comply with international law on minorities as binding in the UK? What would be your comment?
So, in my view, a CPO is prima facie at odds with the need to consult and protect the rights of minorities.
Sorry, could I just clarify what you said there? Did you say a CPO or the CPO?
A CPO, but this CPO as well. So any CPO, but this particular one. Because... Okay, so a CPO is prima facie at odds with the commitment to protect minority rights. Because it does not allow for appropriate participation, it does not allow for appropriate consultation, and then looking more specifically at this CPO, as the documents make aware, there have been concerns around the lack of notice given to the community, the lack of legal representation, the lack of interpretation in a language that the community can understand, all of which would allow for effective consultation and participation of the community as required under international law.
Thank you very much, Mrs. Claridge. Those are all my questions. I understand that Mrs. Santaki is going to deal with sections that cover all the different aspects of the application of this law into this particular case. So I have no further questions for you.
I see. Thank you. Mr. Corner, do you wish to ask any questions?
No, sir, I don't. Thank you very much. I found the answers given to the oral examination-in-chief very illuminating as to Ms. Claridge's attitude to CPO process, and we'll deal with that in submissions. Thank you.
Thank you. So just to be absolutely clear, Ms. Claridge, in the light, and I've phrased these questions in the light of the legal submissions that the Council have tabled. You are saying that international law derived from treaties is binding on governments and on individual local authorities. Is that correct?
That's correct, yes. But I would point out that my role here as an expert is on minority rights, not the question of whether my evidence is admissible or not.
Well, the admissibility of your evidence is not in question. The council may challenge as to whether they agree with it. I need to explore one or two things so that I know, or so that I can form a view as to how to advise the Secretary of State. The international provisions that you particularly rely on are the International Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant on Civil and Political Rights, declarations of the United Nations, the Framework Convention for the Protection of National Minorities. What is it? Under UK law, we have the Human Rights Act, the Equalities Act, and so on. What is it that the provisions under these international treaties and conventions add? What new rights, what different rights do those international provisions add that are not covered by UK law?
I don't believe that the the Human Rights Act has such substantive provisions which apply to the rights of minorities and therefore cultural rights. And I don't believe that similarly, I believe the Equality Act that you referred to, again, covers the rights of ethnic, linguistic minorities to the same extent. So international law goes further in that respect.
Right. The provisions under UK law that have been particularly brought into play in the evidence in this inquiry relate to Article 8 and Article 1 of the first protocol and Article 14, and so those relate to personal and family life and private possessions and discrimination. And what you're saying is added to that by international law is what I think you summed up as protection for cultural rights. Am I right in understanding that in broad terms as a right to practice one's indigenous culture?
I'm not sure that it's an indigenous culture. That's a slightly different concept.
That might have been the wrong word.
It's a right to practice culture, but it's also a right to profess culture, to display culture, to be allowed to gather together and share in that culture. And I think perhaps Alex Santhaki's evidence will touch on this a bit more. But it's not just around practice. It's around having access, for example, to a site, to an area which is a cultural hub, and which appears in this case that it will be denied. Apologies. It's also a question, just because this is the section which actually Alex will cover. So, but it's also a question of ensuring cultural identity, ensuring that is not eroded. And again, Alex will touch on this more, but it's around if this community is not allowed to have access to a site which is their existing cultural hub, then their cultural identity threatens being eroded, because there will be no place for them to continue to meet, to speak Spanish, to celebrate in their cultural diversity, but their cultural shared of identity as well.
Why is that, though? Why is it that the loss, if that was the case, the loss of this building as a social and cultural hub would prevent the continuation of the Latin American community being able to continue to profess and practice its culture?
So, again, I believe this will be covered a little bit more by Ms. Zandaki, but essentially they will no longer have, as far as I understand, an area where they can go and meet together. They will be not be able to afford, for example, the rent to continue their stalls. I've visited the market, and you can see that each stall is set up to celebrate a particular part of their cultural identity, whether it's related to the food or whether it's related to the fact that events can take place in these stalls. And as I understand it, the plans for the new development will not be able to incorporate all these elements and all these stalls for a number of reasons. And there hasn't really been a provision that will allow this cultural hub to continue within the new development, proposed development.
As I understand it, Latin American traders started to operate from the Seven Sisters market, I think towards the end of the 1990s, and then multiplied in number to become the dominant force in it, as it were, in the market. But there was a time before that when it was a market like any other market, if I can use that expression. The fact that it wasn't at one time it was not a social hub for that community didn't prevent it from becoming so, did it? What I'm trying to put to you is, why is it that the continuation of the group's cultural identity now depends on this building?
As I understand it, there's been no provision for them to continue to have a cultural hub in any other place, if I'm correct in understanding the development. And their identity, this is the strongest Latin American community in North London, and they will no longer have a place to meet. They will no longer have a place to conduct cultural activities, to have a sense of their identity, and the market has become crucial and central to their identity and their existence in North London.
But you say no other provision has been made, but no provision was made in the first place. The community made that provision for itself. Is there anything that prevents it from being able to find equivalent provision, as it were, elsewhere under its own steam?
There is nothing that prevents it, but the UK and the Planning Authority is under a positive duty to protect the rights of this community. And again, I believe Ms. Sandaki will discuss this more in her evidence. So I think we're slightly, I know it's a joint statement, but I think we're slightly veering into her area. But all that appears to have been done, from my understanding of the documents, is an agreement to monitor the extent to which the community will be affected. But actually there is a positive duty on the Council and as a planning authority and on the government of the United Kingdom to protect their rights. That doesn't mean not interfering in their rights. That means taking active steps to protect them.
Right. And finally, just to be clear, with regard to the question that you raised there of whether traders from this community would be able to afford the new rents and be able to stay in the new market. Am I right in thinking from your statement, your evidence for that is the views, and the surveyed views and opinions of the traders themselves in response to I'm not sure in response to what, but you've drawn on their opinions for that.
No, I believe, if I could just be given 1 minute to refer to the documents. So there is a quite wide-reaching statement within the Equality Impact Assessment itself, which says that, paragraph 7.3.16, page 52. Sorry, the 2017. There's page 42, paragraph 7.3.16. It says it is unlikely that the planned increase in fees for the new market will have a detrimental impact on market traders if the new market attracts new business and thus provides additional income to cover the increase in fees. But there is a statement as well that the market traders will experience a maximum increase in licence fees of 30% over the first 5 years of opening. I have spoken to some of the traders and understood the effect that they claim it will have on them. I don't see any kind of analysis that has been undertaken to suggest that the new market will attract new business and will not have a detrimental impact. There hasn't, for example, as far as I can see, been any analysis of future profits, and so I believe that all of it seems to be estimation. I don't see any reason to say why it would not have a detrimental impact on market traders.
Thank you very much.
Thank you.
Thank you.